the court heard appeal in the matter of income that was committed and
Mr. Cavender, just before we start, I should embarrass my Lord Justice Cobb by congratulating him on his appointment announced this morning as the new President of the Family Division. So if this appeal had been heard a couple of months later, he'd be sitting in the middle.
Congratulations, my Lord. If I may start by dealing with a bit of homework.
Yes.
My Lord Justice Stuart-Smith asks about the broker agreements the request would have made. You'll see on your bench there a chronology together with a short bundle of some of the procedural documents.
Yes.
I don't intend to go through this in huge detail, but just to give you the heads up, yes, we did ask for them. They weren't provided. It's a bit more nuanced than that because some defendants did provide certain information. So if you look at the chronology,
yeah,
and you'll see in every case there was a letter of claim which contained the passage at the top of paragraph 3 of the skeleton. At the end of a long letter, the letter itself, if you prefer to read that, is at page 4 of the bundle. An example of a scene.
Let me just get this. Yep, I've got page 4. So
this is an example of a letter of claim. You see it sets out the details and make, car, etc. over the top, finance agreement, agreement number, then sets out some propositions of law. Then at the final page, page 8, it says whether or not it's the case we require pre-action disclosure of all documents setting out the commission arrangement between you and the dealer. Such disclosure would be desirable to dispose fairly of anticipated proceedings.
yeah,
That happened in every case.
and so that there are 5,000 or however many of those letters.
Lord, I believe that's the case. Yes.
So this is an example. So this is Mr. Hallsor.
Exactly.
But that's simply an example of
Lord, yes.
a letter from every claimant,
Exactly.
or on behalf of, should I say, every claimant. Yep, understand that.
And if we stick with the chronology, what we then have, 16th November, Mr. Finch.
Where's the request for disclosure?
It's at the end of the letter, my Lord. Look at the end of page 8, the final paragraph.
Thank you.
We require pre-action disclosure.
Of all documents setting out the commission arrangement, you and the dealer, that's the broker agreement.
Yeah.
What then happens is Mr. Finch on the 16th November, via his skeleton, raises the question of challenging 7.3. So within 8 days of us issuing, the 7.3 point is being taken. As I understand, no application was actually made formally, but it was proceeded on the basis that one had been made. We then have the hearing on the 17th of November before he's on Judge Worster. And you'll see, we've seen that order where he disapplied PD 49.
Yeah, we saw that yesterday.
Yeah, and so there's no requirement for the claimant to serve a particular claim. In fact, they should not do so. And they were ordered to serve a generic particular claim, which then they did. Then on the 13th of December, in this case, there's an email chasing the Part 18 response. If you go to page 74, you'll see that. We wrote to you seeking further information. You haven't provided it, please provide it. So that's the basic story. With some of the claims, like BMW, if you go to page 5 of the chronology, in addition to those matters, there's also a pre-action disclosure application issued on the 7th of February in that case. And there's a slight mistake here. PAD application for a wider group of claimants, but including some subsequent omnibus claimants, not all. There's a mistake there, which should be corrected. And similarly, for VW, the same point at page 10, the PAD application including some omnibus claimants. So I correct that. But what you get is a clear picture. We ask for the broker's agreements. They're not provided. We chase. There's an order before the court that we provide a generic fix of the claim, which we then do, and the court then manages it. So that's the broker's agreement. Now, my Lord, dealing, my Lord Justice Coulson, with your concern about whether, in effect, the omnibus claims have been used to prevent providing information, you were provided yesterday with the front sheet of the schedule that was provided.
Yes,
Now, that was provided under court order,
yes.
and it was supplied. There was no complaint about it, it was insufficient. And so it's rather difficult in my submission to see how the claimant to be criticised now, for any reason, for not giving all the relevant information. It's also right that on both sides there were sampling proposals, and my lord said, almost under your breath yesterday to me, well, perhaps our sampling proposals weren't what was required. But the judge certainly didn't think that. If you go to the Worster judgment, it's Core 3, tab 68, his judgment of para 6, page 852 of the bundle. Prior to that hearing, the parties exchanged sampling.
Worcester judgment, paragraph
6, my lord.
6.
6.
Yeah.
Exchange of sampling proposals, Mr. Clark set out the essentials of the claimant's position, the skeleton of May. He developed and modified that approach in the course of submissions. Those developments were welcome, constructive, and sought to respond to matters raised by the defendants. So far be it from any criticism of the process of the exchange of information. That was indeed what the judge had expected and what in fact was done. In terms of those proposals, you've seen some of them. If we go to the supplemental bundle, tab 8, by way of example, to look at the Volkswagen ones.
Hold on.
The supplemental bundle, tab 8. Starts page. The document starts at 102. I want to take you to 109 in this connection. Dealing with the question of questionnaires and what the response of the defendants were. Para 23. Fourth question is, could be sent to claimants in lieu of...
Sorry, you'll have to give me...
Supplemental bundle.
Yeah.
Tab 8.
109.
109, para 23. Dealing with questionnaires. Fourth, questionnaires could be sent to the claimants in lieu of individual particulars verified by statement of truth. This is envisaged an appropriate alternative. Para 24. To submit to the questionnaire approach is to be preferred. So far be it from these claimants not providing sufficient information. The approach of all the claimants and the defendants, and indeed the judge, because he deals with it in his judgment too, is there will be questionnaires. So again, it's very difficult in my submission to criticise the approach of the claimants to have not provided all the information that was understood to be provided. Within a week or two of the claim form being issued, the court had case managed this in a particular way.
Yes, over 5 hearings.
My lord, yes.
And very careful case management up to the decision, which obviously the claimants didn't like.
My lord, yes.
And so then there's the appeal. So I mean, that's why I said yesterday that one of the problems with this is you wouldn't be starting from here. There'd been careful case management up to that decision. That decision reflected all of the points that you're making. They were all considered by the judge. And then there was the appeal, and that's obviously, as per your submission yesterday, what we're principally concerned with.
Lord, yes. And so from my submission, I don't see going over, as my friend said yesterday, in huge detail, the background to the applications before us on the Judge Worster. They really are background matters.
They're not. They're key because they're the case management decisions that were made. You heard my Lord, Lord Justice Stuart-Smith and I yesterday. We take possibly a different view from the defendants to the importance of case management. But that therefore means the importance of the decisions made and the reasons for them by His Honour Judge Worster.
Lord, yes, but there's no dispute in this court that the decision of His Honour Judge Worster was wrong because he applied the wrong legal test.
Well, I understand that point.
So once that...
I understand that point as a result of the permission to appeal. I understand that.
It's also as a matter of law that Morris superseded it and said Abbott was wrong. And
No, Morris said that Abbott was too restrictive, or could be taken to be too restrictive, because it's simply a question of convenience.
Yes.
But the Master of the Rolls was at pains to say that he didn't think that the result in Abbott was wrong.
Well, not the result. No, the test, the three
Because-
so-called exclusionary tests.
Yeah, it shouldn't be exclusionary.
Right.
But of course, in Morris, the judge at first instance had applied Abbott, and his judgment was upheld, even though he'd done precisely what Judge Worster did. His decision was upheld.
Well, yes, but the focus.
I agree with you that that's ground one, and ground one is not a ground on which the defendant's got permission. So
you have to look at
understand
this afresh. What Mr. Justice Ritchie had in front of him, the case had evolved, the submissions had evolved, and it was as matters appear to him on that application that matters. Sure, you can't entirely forget what happened.
You can't, because he is re-exercising the discretion that was Judge Worster's.
Quite.
And the question is whether he did that properly.
Yes. Well, whether he was so out with the discretion. It's not for this court to sit and say, would we have done something different, as you know. It's a very high threshold.
Oh,
and there's a danger with my learned friends approaches.
Oh, that's another. That is another. There's the restrictions of the permission to appeal. There's the restriction that this court should not lightly interfere with any case management decision.
No.
And there are other restrictions as well. So I get all of that. I think we have all those well on board.
Well, yes.
Which is why we wouldn't be starting, if you out of choice, from here.
No. So, with those 2 points made, let me go on my submissions then, because my Lord Justice Stuart-Smith yesterday was asking questions in this area as to why are we in this position? Why is these cases going to Supreme Court? What is going on here? And the unspeakable truth about this appeal is it's not a technical dispute about 7.3 and about convenience. It's really a dispute about whether these claims are going to be brought at all. Because the hard reality is, if these claims are not capable of being brought in bulk in this way, then many of them are not likely to be brought at all. Why do I say that? Because in Abernethy, the PPI case that has been referred to a number of times, that's exactly what happened. All but 1% of those claimants discontinued. Because disaggregated, those claims made no financial sense. And I put that detail, footnote 11, para 129 of our skeleton, bundle 1, tab 23. So that's what's really at stake here. And that's why I said in the opening my submission.
So that's by extrapolation with Abernethy.
The PPI case, yes.
Yeah.
Well, the same thing happened. Disaggregation application was made and successful.
Yeah.
As a result, the claims finished, bar very, very few.
But it comes back to a question which I asked Mr. Goodall yesterday, when I asked him what case management powers would be different, and the answer is they're not. And for example, say we were to decide to reverse Mr. Justice Ritchie and to say that this should be dealt with on an individual basis. We could also give directions such as that all cases, whether they're issued to the four winds or not, be triaged in Birmingham or case managed from Birmingham. There's no restriction. The narrow issue of compendious, what was your phrase? Multi-claim claim forms. Multi-claim claim forms or single claimant claim forms doesn't actually restrict or doesn't necessarily render the action uneconomic.
Well, I have two answers to that. Firstly, if these cases are spread to the four winds, they will immediately be on the small claims track because of the amounts involved. To my knowledge, there's no mechanism to group manage claims on the small claims track. That's the first point. The second point is that your Lordship's point misses the benefits that will be acquired and only be acquired through the process of different claim forms against different defendants. That's already set up conveniently, so there's commonality in terms of the credit agreement, the broker's agreement, and also readily the court could make an order that decisions on those issues are binding.
If individually they're small claims, how can you do them all in one claim form? Because you're on the submission you've just made, you're circumventing the fact that you can't transfer small claims.
Well, you're not circumventing, my lord. It doesn't apply. You're taking these claims together under 7.3, but it does have that effect, as it takes them out of the small claims automatic referral, in effect.
But I don't understand that. If they're all small claims, but they can be dealt with together, and they were dealt with together by Judge Worster, why can't they continue to be dealt with together, even if they are the subject of separate claim forms?
Well, I mean, the short answer to that, one is that they won't, because it's uneconomic. I mean, let's assume the case management situation. Who's going to pay for the representation for these claimants? On a small claims track, you don't normally have a CMC, or it's normally got rid of. The idea you're going to have case management in a small claims court with the defendants all represented by city firms and council, and these individuals turning up, all with representation, which is going to eat into their £1,000 or £2,000 potential recovery. It's just not going to happen. It's not in the real world. And so this goes to convenience, where you don't have any of that. You put them all together and you select 8 or 10 or whatever it is. And that's the other thing about this. You select those, and I said it yesterday, and my Lord Justice Coulson appeared attracted to it, so they are representative of the population of claims. There's no point picking 1 or 2 or 3 and taking them up, because they might be wholly not representative and not get the parties anywhere. This sort of litigation is an investment both by claimants, defendants and the court. So it's very important that the cases you choose are truly representative. So why do you ask, does Johnson, for instance, not carry all before it and say, well, Johnson's the answer? Johnson was quite an extreme case in terms of the percentage of the commission they got by reference to the loan. But we would have cases that covered all the bases. And so they would be truly persuasive on the points that they could be, on fairness and remedy. And they would, in fact, decide the point, as a matter of law, the two broad common issues, particularly the conc issues. Get into the issue about conflict of interest and whether, as I said yesterday, that does poison the well in a case like this. And it's very difficult to think of a countervailing factor which would equalise that or neutralise it.
I was trying to think overnight of previous cases, and this Act has been quite a fertile source of mass litigation. And I was thinking back to the credit hire litigation. And there, what was done was there was a degree of cooperation between claimants and defendants to identify particular wordings, which were then run as test cases. One case was done rather than having, because it was a real problem for the county court in that case. But that's slightly different, because if you interpreted the set of wording, a particular wording once, that was done. And we were at about half a dozen cases went up to the Court of Appeal, a couple went up to the Supreme Court. But this is slightly different on the appellant's case, because it's not. Well, their bull point is that it is not susceptible to having issues that will then, whether persuasive or binding, determine the outcome of other cases.
Lord, that submission, and I think your lordship said to my only friend in a moment, you thought that was absurd, the notion that therefore each case had to be tried separately, because
it's completely my present and personal view, provisional view, is it is completely absurd to think that 5,000 or 30,000 or however many cases there are floating around are all going to be resolved individually.
But Lord, pausing there, that was the alternative the judge was given. So when Mr. Justice Ritchie was sitting in court, whatever it was in Birmingham, he was given the choice of the convenience of carrying on this omnibus claim form, or these claims be sent to the four winds with no management whatever. And that was...
He might have regarded that as the choice he had. If he did, he might have been wrong.
Well,
that might have been the choice that the parties gave him. I mean, the parties have been giving judges limited choices. As we've just been over this morning, we have limited choices. But it's for the court to do its best in the circumstances.
Oh, yes. I need to move on, really, because I need to make some progress if I can. Can we go back to the grounds of appeal? We need to really understand what this appeal is about and what it isn't about. So that's bundle 1, page 8 and following. It's page 21, the grounds start. To impose some kind of discipline on what's being argued here.
It's just 4, isn't it?
It is just 4. So on the way, we look at 3A, and this Clydesdale point. Yesterday, my learned friends, in my submission, completely undermined this failure to get permission on this point, because they say that the judge wasn't entitled to say that Clydesdale did not decide the point, when in fact they don't have permission to argue the reverse. So I note that in passing. I say they're wrong on Clydesdale anyway, I'll take you to it. But formally in my submission, that point is not open to them. If you look at the judgment where he makes the relevant finding, I think it's paragraph 81. So page 459 of the file. In his conclusions, having submitted the decisions on these cases and common issues that not bind in the following cases, the respondent submitted the decision in Clydesdale bound the parties on 2 common issues. I do not accept the non-disclosure issues or agency issues are fully determined by the judgment of Carr in Clydesdale. Be persuasive, but the precise issues in that case may not be the same as the facts and matters which may emerge in the claims herein. In vain, Clydesdale's judicial review of the Foss decision, not an appeal. In my submission, that goes directly to paragraph 3A of the grounds of appeal. That is not a point they are allowed to contest. But let's look at the grounds that they do run in 4, because we've not had any attention on these at all, rather unusually. And you'll see there's no suggestion in 4 that Morris was misapplied. What they say is, if you read A and C together, it's really C. The judge wrongly considered potential sub-issues he had identified were sufficient to satisfy the test of convenient disposal. That's the real ground of appeal under this head. And it's simply wrong. If you look at the judgment, he doesn't do that. It's very clear. If you look at the paragraphs, particularly 71 to 75, where under head analysis of each ground, he identifies at 72 his broad common issues. And if you look at the end of 79, where he closes up this passage, he says, last 4 lines of 79, for these reasons I place more weight on the significance of the broad common issues and objectively foresee that they will be later split into clearer precise issues which have significance to the following cases. So what's stated as a matter of fact in these grounds of appeal is not borne out by the judgment. he based themselves on the broad common issues. He talks about looking forward to the possibility of other issues arising. So those grounds of appeal are, in my submission, a very shaky foundation indeed to attack this judgment. Not even been referred to or made out. So that's A and C. B wrongly criticised the appellants for failing to assist in the identification of common issues. Well, just pause there. They had every opportunity before and during the hearing to say, when I got up and outline my case on agency and on breach of conc, by conc I mean 4.5.3, the disclosure obligation, and 1.2.2, which is the agency point within conc, that they are accepted or conceded, no concessions. So before the judge, they were plainly, and I'll go into some more detail in a moment, two hard-edged common issues, which would apply in every case.
Sorry, they could have stood up and conceded that breach of conc rendered the relationship unfair.
No, not rendered unfair, but there was, in these cases, a breach of conc. They could have said, in relation to 1.2.2, we accept that the brokers are our agent for the purposes of conc. And they could have also said, as they now say in their response...
Sorry, so let's just, this is important, so let's go slowly. It would probably help if you said there were two hard-edged common issues that applied in every case. Do you want to identify those?
By reference to the judgment, I can.
If you say that the judge accurately identified them,
did,
yes.
Paragraph 72, under the headed broad common issues.
Yes.
Reading the judgment as a whole, it's really not in dispute that both regulatory breach...
So what is the first hard-edged common issue?
The first hard-edged common issue is whether these brokers were agents of the lenders under Section 56 of the Consumer Credit Act.
Right.
They did not concede that.
And where does the judge set that out?
He sets that under broad common issue, under 72 he starts, and it's paragraph 74 in particular.
Yes, and there's the reference to Section 56. So that's paragraph 72 and 74 of the judgment. Thank you. And then the second one, the second hard-edged issue,
is the breach of the conc issues. And he does that.
What's the issue?
The issue at 72, was there a breach of conc issue 4.5.3R?
Because
of a failure to disclose
so
the discretionary commission.
So that's the automatic breach because of the failure to disclose.
It's not automatic. It is automatic in the sense, yes, automatic in that sense, yes.
Yes.
Yeah. And the second part of conc.
And that's paragraph 72.
72, my lord, yes.
Yeah.
And then we have breach of 1.2.2 of conc. You're less familiar
Sorry,
with
is
that.
this a third issue?
Well, it's the third issue if you like, yes, but
It's part
Well,
of
it's
your
not if
second.
I like, if it's
it's
what
part
you
of
like.
agency anyway. It's a sub-issue of agency, but it's a conc issue.
Well, we've identified two hard-edged issues, which is what you said there were. Are you saying there's a third, or
My
is
lord,
this?
yes, I am. So if you go to page 429, you'll see 1.2.2R set out. It says, firms must ensure that its employees and agents comply with conc. 2, take reasonable steps to ensure that other persons act on its behalf comply with conc. So if you look at 4.5.3 on the same over the page, 4.5.3 5.3, which is the one everyone's been talking about, places an obligation and liability on the credit broker, not on the firm. The way the firm becomes liable for breach of 4.5.3 is via Section 56 in the agency. That's one route. That's why the agency is so important. Because without that, you don't get into 4.5.3 in liability at all.
So 1 and 3 are linked
Indeed.
of your issues.
And then we go back to 1.2.2r, and the debate there is...
And where's this in the judgment?
He deals with this at paragraph 85. Can I before you go there, can I explain the point first, my lord? Because I don't think this has been the point on 1.2.2.
Can you do what, sorry?
Explain the point. The issue.
Well, you can, but what we're doing is looking at the judgment. But by all means, if it's not in the judgment, then by all means explain it.
Because what 1.2.2 does is makes the firm directly liable for breaches of conc by its agents. This isn't Section 56. It puts a direct obligation on the firm to comply with conc. That's different and more direct than the Section 56 route.
Yeah.
Now, the judge heard submissions about this from me, and at 85 he deals with it. In his narrative there, he talks about, let me assume decisions are taken. 1, communications between broker-dealer and the claimant were antecedent under Section 56. So, Black Horse are liable for the dealer's conduct and omissions. The credit agreement and leaflet do not disclose Angel's interest rates 5% higher than it could have been. 3, the dealer's and lender's conduct were breaches of conc. So he's talking there, the dealer we know about, the lenders, the way that lenders' conduct are breaches of conc is 1.2.2. That's how they become directly liable. And under Section 56, this is dealt with 85.1. This is a separate, distinct liability. And those were the hard-edged, broad issues that the judge focused upon.
But that's not in under the heading broad common issues. That's dealing with a point about fairness.
My lord, it is.
And goes back to his paragraph 77.
But that's also true. But he set it out in his judgment. He's heard submissions on it. And in my submission, there's no other explanation for him for lender liability under conc.
We shouldn't have to be working through this as if it's a jigsaw puzzle.
My lord, in my submission...
When you have common issues, if there are common issues, it's conventional to set those out. And my understanding of the judgment is that that's what he was doing, as you said, from 79 to 75.
Lord, yes. So I'll return to this a little bit in order of my submissions. I'm doing the out of turn now, and we can perhaps...
Oh, sorry, I thought we were looking at the ground 4 of the appeal, and you dealt with 4A and C, and then you were looking at 4B, and you said there were 2 hard-edged common issues.
My lord, yes, but I was just dealing with the grounds of appeal and what was in and out.
Yes, sure, sorry.
So, but no, not at all. I'll deal with things as they arise. Now, if I can then move on to the question of the test and Morris. If you can turn up Morris, please. At bundle 4, tab 44. We've seen this before, so I don't need to spend very long on it. The important points to note is the Court of Appeal were keen, as we discussed this morning, to not overcomplicate this rule and to therefore say the 3 exclusion rules in Abbott were not the test. Not that they weren't relevant factors, because they would be, but it wasn't exclusatory. The first thing to note about this, paragraph 15, although no defence had been served when the judge heard the strikeout, but a draft defence was made available shortly before the hearing. So you'll see there what in my submission is an eminently sensible thing, is that a draft or some form of defence is provided so you can really join the issues. Had that been done here, all these matters are pleaded in generic pleading. 4.5.3, 1.2 for all of these things, and they would require a response.
But the judge said they didn't.
Well, he didn't order a defence, which
so just as you rely on your as it were, your response to my point, well, this hasn't been properly pleaded out, you say, well, the judge didn't order it. The defendants say, well, the judge didn't order us to put in a defence.
Well, that's true. It was asked for numerous times, but that causes the problem of no clear joining of issues. They're not becoming absolutely clear, because a pleader would have to plead to 4.5.3 and 1.2.2. They'd have to plead to Section 56.
Generically, yes.
Yes, but in terms of
Desktop job, yes.
But my lord, in terms of
how that's joining the issues, I remain sceptical.
Well, in case management terms, my lord, it is, because it's setting out what the superstructure of what the common issues might be.
Why do you need a superstructure?
Well, you need a method for sorting out what the common issues are.
And Judge Worster explained that the best way of doing that would be to identify some real cases, and you have said, and I completely agree with you, what you need is some cases which test the limits and the middle.
But my lord, you only
completely right. I completely agree with that.
My lord, so we're in agreement. That's good. But that doesn't.
And that's what I'd like to see, and that's what I would have expected to see in this case after 4 years.
My lord, I agree. But what you need to do before you select your lead cases is ensure the structure of the argument is clear. So is agency an issue or not? Is 4.5.3 an issue? Is 1.2? So then you can choose cases that deal with that issue in a way that is helpful.
Isn't that the wrong way round? Don't the rules and the application of the rules and to any given circumstance depend on the circumstances of the claims?
Well, they do, my lord, but what was being done here, obviously, is trying to sort out because at the time this was done, Abbott was the law, and so the focus of hard common issues was the order of the day. So that's why some of the archaeology of these arguments you need to treat with a degree of caution, because by the time it comes from Mr. Justice Ritchie, it's more broad. It's convenience, simplicity.
I get that. But it would be right, wouldn't it? And your submissions, I think, embrace this, that the identification of common issues of fact or law is one of the ways in to 7.3 multi-claimant claims and sensible case management.
What it is.
So completely understanding that in Abbott they went possibly too far by saying these are the only ways of looking at convenience. And the Master Earl said, no, it's very wide. But at the same time, this is clearly one of the ways in which you do it.
Lord, yes.
Yeah.
So returning to Morris then.
Yeah.
This is the point, my learned friend, he skipped over this bit, paragraph 17, is 17 by D. The judge then noted the existence of individual issues, such as reliance and advice from other professionals. So Morris was a case that did have considerable individual issues. Issues such as reliance and advice from other professionals are quintessential individual issues. But that did not prevent the Court of Appeal saying this was suitable for an omnibus claim form. The way the Court of Appeal in this case, in Morris, looked at this jurisdiction was through the prism, paragraph 43 and 44, of both the Supreme Court Procedure Committee on Group Actions, para 43, and para 44, Lord Wolfe's multi-actions access to justice report. In my submission, this court should bear that in mind as well, given the facts we have here.
Yeah, I mean, multi-actions led to GLOs and group litigation.
Lord, yes, but the Court of Appeal here is saying also preempting aid more generally when looking at the question of convenience under 7.3. 7.3, as we've discussed, is, if you like, the cog on 19.1, which is part of CPR 19, dealing with group litigation. And it gets its flavour in my submission from that. Then we've had 48, my learned friend did take you to, about convenience as a most ordinary word. The question, rather, in what circumstances can multiple claims be exposed in the same proceedings? About 49 at the bottom, at E, I do not think any of these tests are appropriate. It seems to me that 19.1 and 7.3 must be construed as meaning what they say. So there the Master Rolls is expressly joining those two rules.
Yeah.
Go to 51, if you would, off just below D. The case management tools of ordering lead claims and more than one trial, whether of preliminary issues or otherwise, are very much part of proceedings brought by multiple claimants under 19.1. And then at 56, between C and D, the matters that are most relevant to the ultimate question of convenience will vary across the wide spectrum of cases that have and will in the future be brought under 19.1. This court would not wish to confine the discretion of judges in that question under rules that are written in plain English. So what you get from that is a draft defence was provided. There were individual issues, real individual issues, that did not make it inappropriate for an omnibus claim form, contrary to submissions you've heard, where they say any individual issues and you're out, plainly wrong. The test is a convenience as an ordinary common word. Now, if we could then turn, please, to Abbott, it's in Bundle 3, Tab 4.
I don't think it can be Bundle 3, Tab 4.
Sorry, I apologise. Bundle 3, Tab 40, 40.
Thank you.
Now, we'll know this was a claim involving some 3,000 claimants seeking personal injury resulting from hearing claims from three different forces, Army, Navy and RAF, on a single claim form. In Abbott, the Divisional Court allowed an appeal from the refusal by the Master to permit a 7.3 omnibus claim form. And Abbott did so despite applying the stricter test. Despite the fact of the exclusionary test, they still said it was appropriate.
Yeah.
And no doubt the types of exposure and damage suffered by each claimant, with the multifarious operation of equipment in different regimes, in different places, would all be completely different. Nonetheless, it was convenient they'd be disposed of together. So, if you ask the question, were there individual issues in Abbott? Of course there were. There were loads of them. You ask the question, well, if there are individual issues, does that make it inappropriate and inconvenient for a 7.3? No, it doesn't. In terms of the test, if we go to paragraph 52 of Abbott, the court makes the interesting, in my submission, correct point that the test of convenience is only common disposal be convenient. It does not require common disposal to be the only possible or reasonable way of determining the set of claims in question, or that separate disposal would be inconvenient.
Forgive me, I'm behind you. Where
Para 52 of Abbott, my lord.
Thank you. Yeah.
So, paraphrasing that, it has to be a convenient way, not inconvenient.
Is there a gap between convenient and not inconvenient?
I wouldn't like to dance on the head of that particular pin, my lord.
No. I mean, for all normal purposes, that's the question. Is it convenient or inconvenient?
Well, I think, is it convenient? I'll just leave it at that. And it is obviously the fact there are other possibilities,
yes,
and other reasonable ways of doing it doesn't mean to say it's not convenient.
No. And two things derived from that. One, if it's convenient, it isn't necessarily the most convenient.
Correct.
And following on from your submission, the fact that there are other ways of doing the same thing do not automatically mean that it's not convenient to follow a particular path.
Exactly so.
Yeah.
And the other point I could perhaps raise here is a question of timing as to when you look at this sensibly. The judge in his judgment at para 2, last line says, I raise the suggestion here that 7.3 19-point issues might better be decided after generic predicts of claim and generic defence limited disclosure of key documents. That's his kind of saying, well, if there's a new practice direction, that's sensibly what it should contain. But on the timing point, what the judge found was that at this stage, given what he had seen and heard, that his decision was that it was convenient. That's not mean to say at a subsequent time, if there was these all pleaded out and there was questionnaires and all the rest of it, as happened in Adams, remember, say it's no longer convenient for this to be a 7.3.
Well, you could split some claims out. You could say these claims, or claims having certain characteristics, can stay in as aggregated, but there may be others which don't.
Exactly. And if you go to page 463 of the judgment, Roman numeral 9.
Sorry, this is of Mr. Justice Ritchie's judgment.
Yeah. That's his final conclusions.
Sorry, paragraph
463, paragraph 99 at the bottom, Roman numeral 9. At this early stage, I am firmly of the view the omnibus case is the more convenient route to dispose of these claims. So when you take that statement together with his earlier one, well, this would all be much better if there had been generic pleadings and disclosure. He's saying at this stage, faced with this, I'm of the view that this is the more convenient way to go, given where we are and given what needs to be decided.
But at this early stage, he's 3 years after the claim started, not 2.5 years after the claim started,
From an early
and
stage,
after
I think.
five rounds in front of Judge Worster.
True.
I think I might balk at the suggestion that that was an early stage.
Well, I think
The small claims, as I said yesterday, it would have been done by now.
I think he's referring to an early stage in terms of progress. There should have been progress, but these defendants have been very successful at using their financial acumen.
Well, that's the opprobrium part. I'm very anxious not to decide this case on who is most at fault. We're just dealing with the question of timing.
No, but
Rule 7.3 talks about you can have a multi-claimant claim form if it's convenient for the disposal of the proceedings. If you have a multi-claimant claim form, that is the very first thing that you do. So you are already assuming that it is convenient. So the claimants have their foot in the door because they have one claim form.
well, yes, but what?
And it may be inconvenient, and it may be inconvenient from the start. But by the time the court gets round on your superstructure point, to deciding that, you may be years down the line.
But in this case, within 10 days of issuing the claim form, the 7.3 challenge was raised. So, and what happened was, this case has not got to a stage where my lords, I sense, would like, it pleaded out properly so you could have a better look at what you were dealing with. And that would clearly be better. It's what the judge said in paragraph 2 would be better. But we don't have that. These defendants decided to take the point at this point in time.
Well, the judge said they could.
Exactly. But you can't criticise...
Just as the judge said you could provide sampling proposals rather than pleading out 24 of the claims fully.
And we're going to...
So we are stuck with the previous orders.
Lord, we are, but we can't, in my submission, criticise the claimants for that. They didn't choose the timing.
The claimants chose this method of proceeding.
That's
So
true.
it's not a question of blame, but it is a question of whether that was the right method. And if 4 years on the conclusion is it wasn't, that obviously redounds to the claim. It's not a question of fault, it's just how they chose to do it.
Well, yes.
So on the timing point, of course it's a question of convenience, and you have to assess convenience when it's before the court. But we have to, part of the background is that the claim was started on the assumption that it was convenient.
Well, that's true.
I'm sorry to interrupt you. I know we're interrupting you a lot, but can I just see what the alternative would be? It would be possible, I suppose, leave aside pre-action things, to issue a single claim form with one claimant, an individual claimant, and you then take the point, 7.3 point, go to the court and say, we've issued one, but it's more convenient that we do this. You could have done it that way. My lord has been saying you've assumed the outcome by issuing a multi-claimant claim form.
Lord, yes,
I
suppose so.
was just trying to think what the realistic alternative was. I've certainly not, in my experience, which of course is limited, come across a case where where there's clearly a multi-claimant claim coming through, where someone has issued a single claim form and then asked for directions on Rule 7.3. I've never heard of that.
I'm not sure. And also you've got, as I think was hinted at yesterday, limitation issues potentially. Because that, to get that decided, etc.,
Well, we never
appealed.
forget,
We never forget
that.
limitation issues.
We never forget that.
In this court, we never forget limitation.
Or attrition.
Okay, let's briefly look at Adams then. Tab 4, so bundle 4, tab 45. It's been referred to a couple of times by my learned friend.
Yeah.
This is a case, the question was, there had been a omnibus claim form. This was similar to Abbott, another military personal injury case, but this involved not just hearing loss, but also non-freezing cold injuries and PTSD, so even wider. But it was appropriate for an omnibus claim form, replete with all the individual issues you can imagine. And the question here was, given there'd been a settlement in Adams of the issues of liability, was it still appropriate to keep the omnibus claim form going? And both the parties wanted it to, and the court reluctantly agreed. But what it did say, where it went wrong in my submission, is paragraph 27 at the end, where it said, put that differently, if it has anticipated come a stage will reach where the case and the cohort will all require individual determination, and the court may be hesitant to approve the use of omnibus claim form because of the practical difficulties. In my submission, that is wrong. Individual issues in both group litigation orders and indeed in 7.3 are always going to arise. Anyone that's done group litigation knows there's GLOW issues, there are individual issues, and the idea that because you anticipate individual issues, that that makes it inappropriate. In fact, if you look at the white...
Would you agree it's a question of degree?
Well, it's a relevant factor. You know, of course...
Yeah. I mean, it may depend on the nature, scope and extent of the individual issues. As you've demonstrated, there are plenty of cases in which there are common issues, even though some of them could be described when you drill down as individual. So it's going to be a question of fact and degree, isn't it?
Lord, it is, but just for your note, 19 PD 23, para 15.1 of the White Book, your new one at page 586, actually has a provision for individual issues to go off and be heard at other courts under the management of the management.
Give me the page reference again.
It is page 586, my lord.
586.
Practice direction group litigation starts at 581.
Well, I'm blessed with the 2023 copy of the White Book, so my lord has the advantage of me.
586.
586.
PD which?
This is PD 19B.
Yeah.
586 is the trial.
Yeah.
The management court, that's a court obviously seized with the GLOW, may give directions, one for the trial of common issues and for the trial of individual issues. 15.2, common issues and test cases normally be tried at the management court. Individual issues may be directed tried at other courts. What that shows is, built within the group litigation structure, is the idea you do have individual issues. They'll be determined within the group litigation umbrella, and they may be determined by the management court or other courts. Given that, the idea said in Adams that if you have individual issues arising, somehow that makes it inappropriate, is in my submission wrong. And this court should say so. It has caused disquiet, I think, amongst, in other cases as well, within people that do
What we should say
litigation. You should say that the indication that if there are individual issues is like a strong indication it's inappropriate for 7.3 is not the right approach. Not to say it's of course one of the relevant issues and we take into account.
All right, well,
as my lord says, there's a spectrum. It's a question of balance.
Right.
And you just have to make your own assessment, taking that into account, whether the provision of 7.3 is satisfied.
Well, yes, but if you read Adams and the bit I read, they went further. It was overturned, but along the way, it would be helpful to set out what the correct test is. So those are the non-Consumer Credit Act cases referred to by the judge. The Consumer Act credit cases he did refer to. And what I'm taking is very briefly. The first is Chew. It's Bundle 1, Tab 13. I'm taking you to them because my learned friend's overarching submission is, and this is really their only point in my submission, is that there's something intrinsic within 140 A to C that makes it intrinsically inappropriate for a 7.3. Now I say they're wrong about that, and that is shown not least by the fact that they have cases where it has in fact been done before. Mrs. Justice Ritchie wasn't making new law.
you say inappropriate for 7.3, since 7.3 covers all civil litigation, you mean inappropriate for multi-claimant claim forms? Because that
Yes.
7.3 covers every single case in this building.
Lord, yes.
Your focus is on multi-claimant claim forms.
Indeed.
So you say that you're now addressing the point that the defendant's common theme and perhaps principal argument is that claims involving section 148 to C are intrinsically inappropriate for a multi-claimant claim.
Exactly. And if that's right, it's surprising that it's been successfully used in the past.
So you were taking us to Chew, and that is which?
That is Bundle Authorities 1, Tab 13.
And this is Mr. Justice Mann.
The case concerned claims under the Unfair in Contract Regs Act 94 and under the Consumer Credit Act 140 A to C. There were some 100 in number, and they arose out of shared appreciation mortgages. We see that from Para 1. The dispute was whether a glow should be ordered and how the case should be managed. We see at paragraphs 24 to 27, he rejects the fairness in principle argument that we've seen referred to by my learned friends. He then identified common issues, both under go to para 10 under regulation 3.2. The fairly plain paragraph 10 of the judgment, my lord, dealing with regulation 3.2, that insofar as it's plain intelligible language. And it says the banks say that provision excludes any fairness exercise on the facts of this case. And that was one of the issues that the judge said was a go to paragraph 37. You see that that's where he paragraph 37, 4 lines from the bottom. Precise firm can be discussed. I shall give directions for a trial of lead cases in order to get the fairness issues decided, and possibly a direction that regulation 3 be taken as a preliminary issue. To be clear, the fairness issues are the fairness issues both under section 140 A to C and under the unfair regs. So, and if we go to paragraph 34 above, you'll see his reasoning.
Sorry, give me that, before paragraph 34.
37.
34, my lord, yes.
37.
37 is where he deals with what he orders. So a trial of lead cases in order to get the fairness issues decided, fairness under section 140 and under the regs,
Yes.
and possibly a direction that regulation 3 under the regs be separately, maybe a preliminary issue.
Yes.
His
So
rationale for that is at paragraph 34 above.
Yeah.
Fairness questions can best be tackled by taking lead cases or test cases. Sample cases taken which represent various parts of the spectrum.
Yeah.
Technically speaking, the actual findings on fairness notice will not bind other litigants, underglow or not, doubtless provide guidance, the point we said yesterday.
So there's the spectrum point.
There's a spectrum point, and he has the Reg 3 point. We have Conc 4.5.3 and 1.2.2, and agency. And we have the fairness. That's how
And you have the fairness.
we have the lead cases, the 10 or 15 anticipated, would determine the question of unfairness. In fact.
Yes. Not in principle.
No.
Which was a completely misconceived.
Red herring, indeed.
Well, I mean, that was I appreciate you say it's all part of the background, but that was a completely misconceived common issue.
Nor it was.
Yeah. Okay, so anyway, these I get that, and those are the submissions.
And if you look at Mr. Justice Ritchie's judgment, as well in due course, he applies that same thinking. If we look at the judgment at paragraph, for example, 26. Second line, the results made by the parties in the following claims will merely be persuasive. In the test cases and lead cases. And then to 76.
Not common issues.
Not common issues, sorry, my lord?
Not common issues, taking lead cases or test cases.
My lord, I think you misunderstand. The idea is to have lead or test cases, say 10 or 12, and they will decide the common issues. They will also decide.
They will decide those cases, and then from those cases, people will be able to extrapolate your point. No, they're not, quote, determinative, but clearly they would be persuasive because you would have the extremes and in the middle.
Lord, yes. So
it's not a question of common issues. It's a question of here are the results in a range of cases that we've identified as lead or test cases, and therefore they can then be commercially sensibly extrapolated across the piece.
it's both, my lord. It's that, I agree. But also, if there's been a ruling on the meaning effect of 1.2.2 or 4.5.3, that will be binding.
And that ruling would come out of the test case or the lead case.
Correct.
It would be part and parcel of the ordinary determination
In those cases.
in those cases.
Well, we're talking about cross purposes, exactly so.
Yeah. So, well, yes, but it is a question, therefore, of, well, I think a lot of this comes down to, it's a question of case management.
My lord, yes, obviously. And you go to,
And how you do it. And I see, anyway, 34, 37, that's very clear. And you say that Ritchie, Mr. Justice Ritchie, I'm sorry, applied the same thinking, and you gave me a paragraph reference, which I didn't know.
26 and also 76 to 79. We go to 76 under the heading significance. We go to the second half of 76. A sample of cases will be chosen. The various preliminary issues for full trials or just common issues will only be chosen after early disclosure, specific pleading, all matters relevant to 41A and B. Those lead trials will determine the common issues, which would have been crafted with far more precision, further down in line after specific pleadings and chosen cases. So he was following that guidance. And if you then look at paragraph 79, what he takes from that, 79 going to the top of page 458, is it would be a remarkable and brave decision for a claimant in the following case, who's looking at if the claimant lost any of these issues, in the following case to wish to climb that wall and relitigate those issues again on the same brokerage agreement without some specific evidence of verbal statements, etc. Likewise for decisions the other way. For those reasons, I place more weight on the significance of broad common issues. What he's saying is, in effect, these binding issues will have effect across all the population, and the fairness issues will be persuasive. So that's true, my lords. Same point if we go to various Samboras against Bank of Scotland, so that's bundle 3, tab 34. Another case he relied upon. This is a decision of Mrs. Justice Joanna Smith, who had been parachuted into the county court to deal with this. It's a claim brought by 161 consumers in relation to a shared appreciation mortgage. Claims brought under 140A CCA on the basis of unfair relationship on an omnibus claim form. The decision itself involves case management issues, but what you can tell from it is that what they've done is case managed it, if you go to paragraph 4, in terms of 26 pleading claimants, an exchange of individual pleadings for those. From the lead claims anticipated they would be tried. And then what you get is paragraph 4, you have 26 pleading claimants and the identity of 15 claims being identified. So that's paragraph 6. CMC2 on 22nd July, the court gave directions for the trial of 15 lead claims. So you have 26 pleading claims from which you then choose 15. So this was an unfair, similar type of thing, 148C, no difficulty in doing it. The reasoning, paragraph 25, litigation, paragraph 25 of the same litigation is certainly complex, both sides recognise, each requiring consideration of alleged unfairness under section 1 to 40A, same as here. Paragraph 28 is her justification for her orders.
This is all cost budgeting.
It's all cost budgeting, it is, my lord. But she justifies it, if you're going over the top of page 793,
Yeah.
the need for a manageable, extremely lengthy, prohibitively expensive trial of all the claims, etc. So she's recognising the benefit of lead claims to prevent prohibitively expensive and all the claims having to be tried.
Yeah.
So is it new? Is it difficult? Is it intrinsically impossible? No, it's not. It's been done before. And the judge, in my submission, understandably took that into account, and he was right to do so. The only decision the other way is Abernethy. So you haven't looked at that. So it's bundle 4, tab 50.
I think we were taken to it yesterday.
You changed one bit, I think, Lord, yes. I don't intend to take it very much. It's a case mainly involving the application for a glow. When that failed, there was, if you like, a botched attempt according to the judge to then shoehorn it into 7.3. And in the end, she wasn't convinced. 2 points to note about this case. Firstly, the way it had been set up was multi-defendants on the same claim. So not one funder per claim form, but all of them. So the claim form has its defendants, Barks, HSBC, etc., all the people on one claim form. Now that is obviously going to cause difficulties. It's obviously going to reduce the commonality. In our case, that's not the case. Each claim form is for one funder. That drastically increases commonality, because obviously the credit agreements and the brokerage agreements will be the same. It also massively increases convenience.
Yeah.
So does even Her Honour Judge Kelly set her face against a 7.3 in a PPI? No, she does not. Go to paragraph 158, page 1373. It is my conclusion that multiple claimants in the Abernethy claim form cannot conveniently disposed of in the same proceeding should not be interpreted as a conclusion that omnibus claim forms never have a place in claim litigation. Claim representatives undertaking detailed analysis of the claim may be possible to group claims with common themes, etc. For example, it may be possible to identify claims against the same defendant. So she envisages expressly having a one defendant claim form, which she would consider might well be possible. So even Abernethy, the high water part of my learned friend's case, and unfortunately, on the permission to appeal, my learned friends didn't refer to this bit. They say Abernethy was all against, we had 2 pages to reply to it. And the judge, in the permission, expressly referred to it and said, well, she took a different view, let's give permission. But when you look at Abernethy more carefully, there are significant distinguishing features that make it necessary to explain it a bit more than perhaps was done, to understand that it isn't really particularly of assistance to this court. Now, I'm sure I don't need to tell people, given the experience, the benefit, acknowledged benefit of lead cases and test cases. We've seen it in the authorities I've referred you to. I can give you other examples where the principle is generally accepted. One's called Lancaster and Peacock, Bundle 2, tab 30.
Well, you can take us to them if you think it assists.
What? I wouldn't normally, my lord, but the submissions we'd heard from the other side of the court seem to decry and undermine, not accept, the basic principle of group litigation of any type, which is lead cases or test cases do provide persuasive and useful results for the balance of the claims. That's a well-established principle, but it's one that these appellants do not accept. So let's give you another example in a different context. Bundle Authorities 2, tab 30, where Mr. Justice Fancourt, sitting with Master K in a film finance tax scheme scenario, makes the point. So 123 odd claims in the first claim, 33 in the second, in para 1. 2. The purpose of taking sample claims is twofold. First, to ensure issues are common to all the claimants can be decided in a way to bind them all. And second, to decide other factual and legal issues where the decision will not necessarily bind other claimants, but is likely to give a very clear indication of the way in which their cases too will be decided if tried, with the expected consequence that the parties will be able to settle the remaining claims. It is not, of course, necessary to have very many sample claims in order to decide common issues. The purpose of a broader selection of sample claims beyond what is needed to try the common issues is to generate sufficient broad guidance for the like disposal of all the other claims, whose particular facts will vary. So that is established orthodox approach to lead or test claimants, and that is all Mr. Justice Ritchie did. He was entitled to do it, and in my submission, this court should not interfere with it. So, coming to my heading, why the judge was right and certainly not plainly wrong.
Can I just interrupt you for one more time? Don't promise it's the last one. What is, because I may be out of touch, having not been at the bar for a while, but what is the normal way now in multi-party claims of ensuring that what might otherwise not be binding binds members of the cohort? So, I mean, I have direct experience from recollection of a mechanism whereby you have a register, whether you've done leave aside claim forms, but you have a register, and part of the terms of coming onto the register is that you agree to be bound by, or you will be bound by, this, that, and the other.
No, that is still part of Part 19, and there's you can disapply it. That generally, people who are on the register at a time a common issue, so a glow issue is determined, are bound by it unless they apply, and they can seek to have that not to apply to them.
But
that's a general position in
There's no reason
glows.
for that not to be translated across to a non-GLO piece of litigation, is there?
Well, so the question is, there's no reason why it shouldn't be transferred.
Yeah.
My lord, no.
Because I think your answer was that that was specific to GLOs.
Yes.
And my question is, surely you can translate it across as
Indeed.
case management.
Indeed. I mean, 7.3 is deserving of a practice direction, perhaps, because it is a growing area and it is perhaps fertile ground for some of these rules to be set out. But, my lord, yes. But the way it would be done short of a practice direction at the moment is if all the claims are on a single claim form.
But it's easier if they're not spread to the forwards.
It is, because they're on the same claim form. Then, as case manager, say, right, in relation to these claims, we can decide these issues for the construction of this broker agreement, because there's one defendant per claim form, remember, and it will bind everyone. You can't do that on the four wins. You can't do that if all the claims go to small claims courts all over the country.
Not easily, at any rate. Not conveniently.
Not conveniently, my lord, no.
Just anecdotally, Mr. Camden, given that you've referred to, maybe 7.3 needs its own practice direction. Having made inquiries, my understanding is that this point is back on the radar of the CPRC, primarily because of concerns about multi-claimant claim forms and the use of multi-claimant claim forms, particularly in Birmingham County Court, who are apparently swamped with thousands and thousands of claimants on a single claim form. So my understanding is that it is going to be looked at again, but I don't think anybody should be holding their breath that anything is imminent. So I just provide that to the court for what it's worth.
So going then to my next heading is why the judge was right and certainly plainly not wrong. When you look at the judgment as a whole and you turn it together, it's a careful judgment, a full judgment reached after a hearing of 1.5 days. I've referred you to paragraph 2, where he makes the point that it would be better if the claim had been further along and been a generic defence and some disclosure before he dealt with the issues. At 13, he sorts out the chronology, and in para 14, he summarises the content of the generic particulars of claim. And he makes the point that they're all generic and common allegations, as indeed they are. And he makes the point at para 15 that they don't contain any facts relating to each of the relevant claimants. He then makes the point, understandably, at 15, underneath the Roman numerals, that a point my Lord Justice Coulson's made is the parties have been so bogged down arguing over issues, what they might be. And he makes the point, in my assumption correctly, the claimants have been trying to guess what defences the defendants will take. The defence are refusing to say what will be an issue, which is how it appeared before him and was what happened at the hearing.
So he didn't know that Judge Worster had said they didn't need to put in defences?
Well, leaving aside the defence...
Just what's the answer to the question? I mean,
counsel...
You have answered a number of my points very fairly by saying, well, Judge Worster didn't ask us to do this. This is an express criticism which comes up again and again in the judgment of the defendant for not doing something which Judge Worster effectively disapplied them from having to do.
Well, my lord, leave aside the defence for a minute, because that's a fair point in relation to the defence. But when I'm on my feet putting points, very fairly, the two broad common issues, over 2 days, the defendant counsel had every opportunity to concede those points. It wasn't Mr. Cavender banging on about. We accept the Section 56 agency point. We accept that Kong applies and that there'll be a breach in the event it's not been disclosed. We accept that...
And they say those don't add up to a row of beans because they wouldn't be determinative of anything. Because those points don't lead to a conclusion that the relationship's unfair. That's my understanding of the point after 4 years that's between the parties.
My lord, yes, but they can't say they're not relevant, that they don't get to choose that. It's our allegation, our case, and is obviously right, by the way, that if they're in breach of conc, a duty to disclose, that, and in fact, Miss Justice Worster said it in Kerrigan, that on the face of it, that's going to be a powerful factor, at the very least, to show unfairness of the relationship.
I get that.
So their case on that is important to know whether there's a common issue that arises out of the construction and application of that rule or not, or whether the parties, there's nothing to say about it. In 1.2.2, do they accept that the brokers are their agents for their purposes of their liability under 1.2.2? I still don't know. In our responsive skeleton, we say, well, thanks very much for the indication on section 56. What about 1.2.2? Silence. You've heard nothing today either. Yesterday. So one must assume that that's going to be an issue. And if it is an issue, it's a common issue to all.
Yeah.
So the judge had very much in mind, at para 20, the conc rules, and sets out the guidance. He then sets out the test in Morris at 21 and Abbott. He then gives heads up in his conclusion at para 27. And then what we get at para 33...
Just reminding me, Route 1 is separate claim forms and Route 2
Correct.
is what he calls an omnibus claim form,
Correct.
a multi-claimant claim form. Yeah.
For 33, he sets out the relevant factors. No one's suggesting or criticised that these aren't relevant factors. That he's taking into account a factor he shouldn't have done or didn't. No one's criticising para 33 or saying they are not relevant. So he's clearly applying the right test. At paragraph 34 and following, he then sets out the various guidance from first instance case law, and he does so carefully. Look at the penultimate line on para 34. Cases on glows are not the same as cases on omnibus claim forms. Glows are stricter and have stricter criteria set out in CPR 1920-22. So he was very clear that he was looking at these cases with his eyes open and looking for the right things. He then looked at the cases I've taken to you, Chew, SAM Borrowers, Moon I've not taken you to, Adams I have. Kerrigan was obviously a decision at 39 of is on Judge Worster. And he deals with Abernethy at 41.
Yeah.
At 42 then, under heading the judgment, he goes through the judgment. And then at paragraph 47 following, he goes through the test, and the wrong test, and other common significant issues in ground 1. And if you look here, this is another place we get the 122 reference. We go further, the appellants assert the issues over the conc obligation.
Where are you?
In the middle of 47.
About 6 lines up from the bottom.
447, 6 lines from the bottom, Lord, yes, in paragraph 47.
Thank you.
Further, the appellants assert the issues over the conc obligations on the lenders to ensure that agents comply with the conc guidance. That's 1.2.2. That is the obligation. If you want to check that, the rule is page 429, sets out 1.2.2r, a firm must ensure its employees and agents comply with conc. That is what it's referring to. He then outlines at 51 following the appellant submissions. And then at 56, he summarises the appellant's grounds. There were common issues as far as they could determine evidence of offence and solve specific pleadings before seeing the brokerage agreements. Then see 59 and following, the respondent's submissions are set out. The famous Finch factors.
Just noting it as we pass it, the reference at 58, has that happened?
My Lord, no, there's been no amendment to include any of those, no.
Hugh? Yeah, so then we have the respondent's submissions summarised from 59.
Indeed. And then we have at 71, which is really the meat of the judgment, or the summary, if you like, which we've been through a few times. Firstly, outlines the test, goes back to the broad common issues that we've been through a few times now, and I won't take you to again. The two broad common issues, i.e. agency, breach of conc. And if you look at the bottom of 72, I set out generic the particular claim assertions above. Each may be seen to be denied. They cover interpretation of conc, scope of conc, what would be a breach of conc in various factual circumstances. So he's clearly into the detail and clearly understands what he's being asked to do and the submissions he is receiving. Then at 75, he registers his disagreement with His Honour Judge Worster in relation to the agency issue. You recall His Honour Judge Worster said, for reasons I don't myself understand, that he thought the agency issue wasn't sufficiently common. But of course, it's absolutely central to every case. It's the only way you make...
Well, I think to be fair to Judge Worster, that's not how it was advanced before him. The agency issue is one of the issues that has taken on a stronger life as these proceedings have gone on. It was raised before him, but it was not said to be a common issue. There was only one simple premise in front of Judge Worster.
Well, we'll have a quick look at that. Paragraph 40 of the judgment, my lord, so we're in bundle core 3, tab 68, page 863, paragraph 40.
Yes. I had in mind 33 and 34, which is where he identifies
My lord, yes.
the issue.
I understand that, but then you go to 40.
Yes. And then this is the further material provided post Abbott.
Indeed, and you'll see there, we're dealing here with 1.2.2R, the agency issue under conc.
Yeah, no,
and more generally.
I've circled those references.
Lord, yes. So it clearly
Wasn't put as being the single common issue that should be decided.
My lord, no,
It's
that's
now loomed into greater significance. I understand that.
Lord, yes.
Things change. After 4 years, one would hope things change.
Lord, yes.
But I don't think it's fair to criticise Judge Worster for his response to a moving target.
Lord, no. I don't seek to criticise him. All I'm saying is here, this is where Mr. Justice Ritchie disagreed, and at least by the time it came before him.
Yeah.
Agency, in both its guises, Section 56 and 1.2.2 was very much a common issue.
Yeah.
And then under paragraph 76, significance, and then hypothetical. And what he was doing...
On the headline significance, one completely understands what the judge is doing there. Of course, significance was something that was in Abbott, and which Morris tells us is an exclusionary, is a wrong exclusionary test.
But Lord, that's fair. But
we don't criticise. I don't criticise a judge for saying, well, this is a significant issue, and therefore one that might lead to it being conveniently disposed of.
I think that's what he's saying here, my lord.
Exactly. And that is in that sense, the artificiality of this whole business of, is it Abbott or is it Morris? Actually, they're saying the same thing. It's just in Abbott, there was the risk that they were cutting out other things which might be relevant.
Lord, I agree.
But I laughed when I saw significance, because I thought,
Coming back in.
Yeah, exactly. But he's right.
Yeah.
I mean, whether the analysis is right is a different point. But you can't criticise a judge for trying to identify issues that are significant,
No.
whatever Morris says.
No. But well, Morris, to be fair to it, when you read it really carefully, doesn't say these are not relevant factors.
It expressly says they may be, and they were in Abbott.
Exactly.
Which goes back to this point that it's all a bit artificial to say, I think, well, you erred because you complied with the test in Abbott.
No, yes.
Anyway, there it is.
And so, hypothetical, what he's doing here is explaining the reasons for his decisions in terms of the lead cases and their effects and how he sees the litigation working and why he thinks that it's going to be important to have these decided lead cases, decide the common issues and the general issues. Because whichever way that goes, this is the top of page 458, that is going to be, amongst hard-headed commercial operators like the defendants, is going to be influential, to the point my lord said to my own friend yesterday. And so what he's doing is making clear that that's very much what he has in mind. He then says at paragraph 56 that he found that the limited effect that his Honour Judge Abbott thought that the test cases would have was too limited, and they would have this broader effect, i.e. persuasiveness. In my submission, he's right about that.
Sorry, which paragraph are you in?
Paragraph 86, my lord.
Oh, 86, sorry.
86, my lord. He also recognised, actually 84 going past that he recognised that the in principle led to confusion on fairness originally. So he's noting that it was run that way before him, which I think we all agree.
Yeah.
Then under 87, significant decisions on common issues. The last 3 or 4 lines of that will not happen for separate cases which will be dragged into the small claims track or the fast track because the value will heavily influence allocation. I consider the decision under the omnibus route by the appropriate level of judge would be at least persuasive in relation to conc, breach, agency, and many likely precise sub-issues.
So what he's contemplating is getting to a stage where a selection of cases which raise this issue individually will be tried out, will be case managed to trying out, in the hope and expectation that decisions on that range of cases will prove to be A, binding or at least influential.
Lord, yes.
Standard stuff.
Yeah. Absolutely standard. So we then come to the overriding objective.
So, can I just follow that for 1 second?
Lord, yes.
So, really what it boils down to is that unless the appellant can undermine that as a proposition, we're just in standard territory.
Lord, you are. Unless they can succeed on their... they say this in their skeleton, that their fundamental submission is that Section 140 A to C cases are intrinsically unsuited to 7.3. Unless they can get home on that, and my submission plainly they can't, then it's difficult to see why we're not in standard territory.
Well, they'd have to refine it to say these Section 148. Well, maybe they just go so wide as to say you can't do it.
Well,
when Section 148 is in issue.
Right. Which in my submission is deeply unattractive. And
well, I don't mean it's wrong.
No, but it completely ignores the flexibility that modern case management tools
Yeah.
and group litigation have been developed since 1999. Then G4, the overriding objective. He deals with about weighing claims in the balance, etc. And he then, at 89, summarises what he calls the factors. So this is his summary, which then reaches back into his reasoning beforehand.
And this picks up his earlier point about the choice between route 1 and route 2.
Well, yes.
That's not actually the issue, though, is it?
Well, the issue
is if he was
convenient.
exercised exactly. The issue is convenience under 7.3. Where does the judge identify that as the test that he is endeavouring to meet?
Does that, my lord, at para 21?
Well, no, 89 is his decision to exercise the discretion afresh, but he appears to assume that the discretion is the choice. And I'm just questioning that. I don't think that's right, is it? It's a question of convenience.
Well, yes, I mean, to be fair to him, he sets out, sort of pursuant to Morris, the court should exercise discretion in CPR 19.1.
Yeah.
He's then set out at para 21 what that requires.
Yes, I understand that.
Yeah. And so what he's doing is applying that test to see what is convenient on the facts before him in terms of the arguments that have been ranged before him.
Well, I'm not sure that's how 89 reads. But anyway, because 89 is put, which is the right choice. Anyway, there it is. And you say these are the factors that, although he doesn't use the words, is this right? These are the factors that are convenience?
Yes.
But to balance, he puts the factors in, giving them, and gives indications that with some that he finds them persuasive and some that they're less.
Exactly so. And so, for instance, he deals with where claims relate similar matters in, say, Roman 3.
And also, subparagraph Roman numeral 9 on page 463, I think may be an answer to my Lord's question.
Yes, at the end.
Yeah.
Yeah, no, I've got that. Yeah. I'm done.
So, in my submission, that's a careful going through. There's no criticism that these factors weren't relevant. I guess my own friends would say, well, he maybe put too much weight on one or the other. But in a case where you're trying to say the judge was plainly wrong, that won't pass muster. They've not identified, either in their grounds of appeal or in their submissions, any failing in this judgment beyond their big point. So, can we then go to Clydesdale? Because that's a sort of...
Are we leaving convenience?
We never leave convenience.
You both said that, one in that ear, one in that ear. Is it a convenient moment for me to ask you a question about convenience?
Lord, of course.
I was wondering, it slightly begs the question, understanding what the Master of the Rolls says about convenience being a test that's been in the CPR for 100 years. I was wondering, convenient to whom? Presumably, one takes into account convenience in terms of disposition for the claimants, for the defendants. And it occurred to me, what about the court?
Lord, yes.
That must be, I mean, I think to be fair to Mr. Justice Ritchie, he touches on it at one point because he has a bit about fewer judge hours.
Exactly. Well, that must be right in the way the CPR is set up and the various other obligations.
Yes.
The overriding objective in other places.
But as far as the court is concerned, obviously multi-claimant claim forms, particularly if there are thousands of claimants, impose a particular burden on the court. And so, is that a factor?
It is, my lord, yes. Plainly.
And that then gives rise to the separate point, but I think it's related. Should the court take into account the fact that if you have a multi-claimant claim form, there's only one fee?
My lord, no. No part of the judge's function when exercising discretion under 7.3 to either fill or empty the coffers of the court service. There can be no part in my submission of the exercise of that discretion.
But doesn't that go to the justice system and the need for that to be adequately funded? And therefore, without wishing to sound pompous, the rule of law?
My lord, no. I mean, in my submission, that's out with the discretion. The discretion of the judge is looking at this case and the convenience for this case. You can look at the use for other court users and for the convenience of the court and buildings and other man hours and those sorts of things. But to also take into account the financial impact on fees or lack of fees, in my submission, would be going too far.
That's you would say that's a matter for the government to decide on the appropriate, because they could say people with 1,000 pay X pounds, people with 2,000 pay Y pounds.
Correct.
But that's not our concern.
No.
But I think you do accept that the relative burden imposed upon the court system and resources, in terms of judicial resources, building resources, and so on, that can be a material factor.
It can. And again, I go back to what the alternative is through the convenience lens. There is no alternative other than each of these 5,000 claims be tried out separately with disclosure, with the CMC and a hearing. It is, I say this rather than from the bench, it is absurd that submission. That is a viable alternative.
I get that. No. Well, you've been very helpful. It just suddenly occurred to me. I have to confess, in the middle of the night, I woke up and I thought, convenient to whom? Shows I don't have much of a life. I thought, convenient to whom? I know that there is a bit.
Buses was probably still working.
I know there's a bit in Abbott where I think it's Mr. Justice Baker says that the fee question isn't relevant. But I seem to recall it also cropped up, I think, in argument in Morris, but yes, in Morris, but it wasn't something that was featured in the judgments. But anyway, you say the question of fee, that is outside the judicial discretion.
Lord, yes.
Yeah.
Now I take you to Clydesdale, again, one of these cases that's been in the background. I say the point my own friend seeks to take and says, well, Mr. Justice Ritchie was wrong to say Clydesdale didn't determine a conk point, for instance, is not available to him. But I want to take you to it to show you that he's wrong about that anyway.
I understand the point about it not being available to him strictly because of ground 3 not having permission.
Exactly.
But it isn't Clydesdale, it's a case, it's been relied on. Don't we have to reach a view about it if it's important in any event?
Well, that's why I'm taking you to it.
Fine.
Yeah.
I mean, it was your exclusionary test that I was just...
Well,
I understand what you say about ground 3. Of course I understand that. But if we thought Clydesdale meant X, then, and we thought that that was relevant to our determination, we should say that, I think.
Well, you should, but I don't think you can criticise the judge for the view that he took for seeking to undermine the exercise of his discretion, because that's not available to these appellants. Let's have a think about that. But let's look at the case first.
It would be slightly odd if we thought, I mean, I have no idea whether that would be our view, but if we thought the judge was wrong in his interpretation of a case, and we thought that that was important, it would be difficult to say we should say that.
Lord, I see that, but
anyway,
it's a very narrow permission that's been given by this court.
The narrowness of the PTA is forever in my consciousness.
But let's look at Clydesdale on that basis.
And give me the reference again.
It's bundle 4 of the authorities, tab 49.
Thank you. Yes.
Now, this was a JR against the upholding of a complaint by a customer for breach of the disclosure obligations in conc, resulting in the finding of an unfair relationship under section 140A to C, and the consequent compensation by an ombudsman. We say it's helpful to us, but not determinative. Firstly, because the finding of the judge on the hearing was understandably in the form of it was open for the ombudsman to find, not a determination that his construction was correct as a matter of law. I'll take you to that. It also was a finding that in some cases it might be possible to say there's a duty to disclose, but disclose more than the mere fact of the commission, but doesn't say what cases. And that's not an idle point, because in Clydesdale there was both a fixed commission and also a DC commission. So as well as the discretionary commission I've spoken about, there's also a fixed one. And so that brings up the, if you've got two, is there more of an obligation to disclose because of the difference? There are two. And that was very much part of the reasoning. So if you go to the head note, if you would, page 1261, and this is a classic case of what I said about the pernicious nature. So 3 lines down, the broker had a discretion to set a flat interest rate payable by a customer to the finance company between 2.68% and 15%. So to understand what that means, the broker can either charge 2.68 and get no commission, or 15.25 and get all of the extra interest for the term of the loan for the, between those two percentages. The amount by which that rate exceeded 2.6 was payable as commission by the claimant, which also paid the broker's office a fixed commission. So those are the facts. And so you can see why I say, and this is the only case you've been shown involving a DC commission.
Yes, I like that. I understand that.
Yeah, and you'll see later my submissions yesterday about the conflict of interest, which exists in a DC case. It doesn't exist in a normal commission case. It's just a failure to disclose. But in a DC case, the conflict of interest is you're talking to a dealer not knowing he's negotiating with you for the interest rate. And moreover, that he gets all the benefit from the high interest rate. Now, that doesn't happen in a normal commission case. That's why I say the engine of our cases is so different and so powerful. That's the poison the well point. So returning to the case then, we can see at paragraph 88, the heading FCA Handbook Provisional Interpretation.
Can you give me a page?
It's page 1283, my lord.
Thank you.
And you go over the page to 1284, you'll see the various conc rules there being looked at. And the thing to take from this, the conc rule I've been referring to is at page 1285, 96, conc 4.5.3r, commissions, credit brokers. That's the one we're talking about here. The credit broker must disclose to a customer in good time before a credit agreement or consumer hire agreement is entered into the existence of any commission or fee. Now, I'm sure you've got this, but this was the conc rule at the time here. It changed in April 21 to say existence or nature. And so in this case, the argument was, well, because that was brought in 21 and needed to be, therefore it wasn't there in this version of the rule. So that's the debate. The other point to get from this page is, although we talk about 4.5.3 and 1.2.2, although the latter wasn't raised in this case 1.2.2, that dog didn't bark. But although we concentrate on 4.5.3, as you'll see from 93 and following, there's a whole lot of other rules, 3.3.1, 3.7, 3.7.4, that surround 4.5.3 to give it meaning and effect and colour. It's not interpreted on its own, and that's what we see the judge doing here, just so you have that point. And then we have paragraph 116, the judge setting out, Ms. Justice Carr, the basis on which he was proceeding, referring to Stanley Burnton, LJ's decision in Heather and Moore, that Ombudsman was under FOC statutory scheme free to depart from the common law. The Ombudsman's broad judgment as to what is fair and reasonable was different from common law actionability. So that is the...
Yeah.
We then go to the construction of page 189.
Paragraph 189.
Paragraph 189, page 1299.
Mm-hmm.
So those provisions read together to be holistic. And then over the page, 192, we're focusing now on 4.5.3, referring to the regulatory archaeology. And then the conclusion at 194, I've reached the conclusion that 2018 Conc 4.5.3, using the word existence simpliciter, i.e. rather than with the additional word, say nature, is already wide enough to require, in some cases, I emphasise those words, disclosure of more than the bare fact of the commission, fee or other enumeration would be or could be payable. So in some cases, it was open to the Ombudsman, in my judgment, to decide that this was a case in which disclosures fell short. So what he's saying is, in some cases, and I'm not interfering, it was open to him. He's not saying as a matter of law, this is I determine this. The Ombudsman reasoned that the conflict of interest, this is para 195, was particularly acute because two separate commission payments were payable to Arnold Clark, head office commission at 2% and the discretionary rate determined by the payee. The former, had it stood alone, would have been inadequately disclosed, etc. And then at 197 below, it was for the Ombudsman to decide what level of disclosure would meet the requirement to disclose the existence of any commission. So what's going on here is a reference to two commissions in some cases, and the Ombudsman was entitled to. And then over the page at the top below, 2 lines down from the two were treated as separate kinds of remuneration in the then wording of 4.5.3. The phrase was any commission or fee or other remuneration payable. The conditional sale agreement referred to commission in the singular and without further particularity. The extent of disclosure was inverse proportion to the acuity of the conflict of interest. And then he goes on, I reject the contention that finding a breach of Conc 4.5.3 proceeded from a misinterpretation of the rule, where there are two separate kinds of commission. Conc 4.0 applies equally to both. So what you get from this is that the judge saying that in some cases it's conceivable that more than the mere fact of disclosure the commission might require, you might have to disclose the nature. In a case where there are two commissions, the conflict is particularly acute, and particularly when there's a reference to one commission. So although it's helpful to us, what the judge's conclusion was that in the absence of defendants conceding the point, that they could easily wriggle out of Clydesdale before, and this is me saying this now, a deputy district judge in a case, and say, well, there are two commissions there, they're talking about the conflict of two commissions, and it's in some cases, and furthermore, all the judge here is doing is saying, well, I'm not going to interfere with the Ombudsman, that's the view he can take. So I'm not saying it's irrelevant, obviously, but it isn't binding in the sense of a common issue would be that's selected in a series, say, 10 test cases and decided, where you would have a proper binding issue on the meaning effect of 4.5.3 across a broad range of circumstances.
it's slightly ironic that in a case where the appellants are saying, well, you can't come up with a solution where anything's binding, but they refer to this as being something that's been effectively decided, you say, but it's not binding.
Well, it's helpful, obviously, but in terms of, they're saying, therefore you don't need to have a lead or test case with conk as an issue that's determined on the facts of a broad range of cases.
Yeah, no, I understand that.
And I say, well, it doesn't do that.
Yeah, no, I understand.
We don't have a formal concession from any of the appellants that they are bound by Clydesdale to make certain.
Well, no, there was an appeal against Clydesdale.
Yes.
That was then withdrawn or settled, I don't know what, but there was an appeal.
No, but I was just picking up on my Lord's point, I think, where although the appellants are saying it's all very important and it settles everything, we don't have a formal concession.
No.
That it actually binds or determines anything for any of these cases.
Right.
Yeah.
Now, the topic I'm going to go to now, having set out that, is to meet head on the case on the holistic case, which proceeds on the basis that everything's relevant, therefore you can't have lead cases. I'm dealing with that point now. And our submission is that whilst it's true that the legislation, which is section 140A sub 2, and the courts in Plevin, Smith and Johnson, the parts my learned friend showed you to, talk about all relevant matters. When one's performing the balance in a DC case of whether the non-disclosure makes the relationship unfair, we don't rely on other factors. In general, this is our factor. The omission to disclose the fact of a DC commission in the sizes that were done made that relationship unfair unless the defendants come up with some factor that is so persuasive that although the conflict of interest in that situation is so manifest as to poison the well, nonetheless does so. Now, those matters, they've not indicated a single one, before your lordships, or before...
Sorry, say again?
They've not indicated what those factors could or might be. They refer to the Finch factors. Let's look at the Finch factors. The judge set them out in his judgments, in a convenient place to deal with them, at page 451. And just cast your eye over them and ask the question whether any of these conceivably could tilt the balance the other way round to discharge and ignore and excuse the conflict of interest inherent within a DC commission. From the FCA work that's been done, there's no indication that any DC commission has ever been disclosed.
Sorry, paragraph they're set out at...
Paragraph 63 at page 451. And what I say is that it's obvious if you're going to run a DC commission arrangement, it has to be kept secret. Because if the customer knows that you can, in the Clydesdale example, could get an interest of 2.68, the lowest, he's going to ask for 2.68. So it's part and parcel of having a discretionary commission that it's kept secret. Because if the customer knows, he's obviously going to say, well, give me 2.68. That's the lowest you can offer by the funder. I want that, please. And you've seen the reference to conflict of interest in Clydesdale. So then look at these factors. And they're all just so much of nothing. The date of the rules, whether there was a commission. Well, obviously, it's only if there's a commission we're in this debate. Was it a discretionary commission? Well, if it isn't, it's not in the action. Was it disclosed? Well, obviously, and the amount. These are all just the interest rate that was charged. These are all just normal incidents of the relationship. None of them, even arguably, could go to the balance on the other side to say what was unfair, conflict of interest, that the charging of this discretionary commission tilts the balance the other way. None of them. Some of the ones at the end, like was there a deposit contribution stuff, go to quantum. That might go to remedy. But they don't go to unfairness. And so what you have is these appellants talking about holistic and everything's in. When, in terms of case management and convenience, you have to drill down a little bit further and ask, well, are there really all these factors? What are the countervailing factors that would meet the basic charge of unfairness in principle because of the conflict of interest? A breach of the conc rule, 4.5.3, has not been disclosed. What's the answer? I ask rhetorically. We have had none. None in the skeleton, none in the submissions. Because there isn't one. And so the reference of a lot of other factors, which whilst in existence don't move the dial one way or the other, is effectively camouflage or smoke and mirrors. A similar thing happened in a case called Scotland against British Credit. If you take it, Authorities Bundle 1.
Hang on a minute. Yes, Authorities 1.
Tab 18. This was a...
It's a strong call.
It was the supplier selling windows and doors, and for a loan, it was a PPI case.
PPI.
PPI. But obviously, Section 148 case.
Yeah.
And the point I want to take you to is at page, paragraph 86 at page 307. The criticism of the judge by Mr. Tolley here. 4 lines down. Mr. Tolley continued, she failed to take into account the following highly material factors which showed the relationship was not unfair. And you'll see them. First, nothing suggests Species acted culpably. Second, communications, the claimants were clear. Third, no question interest rate applicable had been artificially reduced. Fourth, did not receive the premium itself. Fifth, etc. And 87, the Court of Appeal says, well, obviously they must look at the thing widely. And 3 or 4 lines down further, if there are any matters relied on by the debtor which point to the relationship being unfair, the court must clearly take into account any countervailing factors or matters which put those matters relied on by the debtor into perspective, and so may affect the assessment. That's my move the dial point. I'm not just talking about factors that exist, they must move the dial. And then 3 or 4 lines down, the further matters now relied on Mr. Tolley clearly do not contribute to the unfairness of the relationship, but nor, it seems to me, do they diminish or qualify the impact of the matters relied on by the claims as giving rise to the unfairness. In my judgment, it's not incumbent upon the court carrying out the assessment to identify all those matters which do not affect the assessment one way or another, and yet it seems to me that is exactly what Mr. Tolley is criticising the judge for failing to do. So what you see there is potential Finch factors and other things that are there. But what you've got to do is, according to the Court of Appeal in this case, put those matters relied on by the debtor into perspective and so may affect the assessment. So common, ordinary factors that exist will not move the dial. And so that is an important principle.
But do you say a court, when considering whether or not it's convenient to have a multi-claimant claim form, has to look at the potential issues way down the line and come to a view as to the weight to be ascribed to those issues, all before deciding whether or not it should be a multi-claimant claim form?
No, my lord. Well, what I'm doing...
That seems to me to be incredibly burdensome.
My lord, I'm not...
7.3 doesn't envisage anything other than surely a broad brush judicial, if it's challenged, a broad brush judicial evaluation of whether or not it's going to be convenient to dispose of it in this way.
Yes.
Your submission is, when looking at Finch factors, bear in mind what Justice Kitchen says and discriminate between things that really matter and things that are white noise.
I couldn't put it better.
Well, that's your submission.
But at what stage do we do that? That's what I'm...
Well, you do it as part of the deciding convenience, because those are the submissions.
But that's are you saying that that's what a court should do
Well, the courts
when
look at-
deciding convenience under 7.3? It's that I'm questioning.
But it has to look forward, doesn't it, to how it envisages the action continuing. And that's why you have the hypotheticals and Mr. Justice Ritchie setting out how he thinks this is going to develop. And it's inherent
We're
within
providing
that.
a judgment that you said yesterday was going to be of importance as to how these claims are to be decided. Speaking personally, I am not going to be saying to judges, oh, in addition to all the other burdens that you carry, you are going to have to do an evaluation of the weight to be ascribed to every issue. It may be that that's something for this appeal because of the situation in which this case has got, but
But, my lord, I'm
we're
agreeing
very
with you,
troubled
because-
about doing that.
because it is a broad brush thing. At one stage in time, you say, is it convenient? Now, it may be, as I said earlier this morning, that later on that shown to be wrong at a later stage. So that gives you the broad brush snapshot approach. And that must be right. I have to make this submission because in my submissions, the only coherent submission we've had from the other side is this fact that it's intrinsically such.
Yeah, no, I understand that.
Yeah.
And I understand precisely why we're looking at this. I'm just trying to see it in context. Yeah. Okay, that's helpful. Thank you.
Now, in terms of the factors that you'll take into account on an unfairness claim, you can show Johnson, which I want to return to briefly. That's in Authorities Bundle 4, tab 52, page 1406.
Thank you.
And you've been shown this by my friend. It starts at 1485, the 140A point. And you'll see at 319 the various factors that the court set out at 319.
I'm very sorry. What page are you on?
Page 1492, my lord.
Thank you.
Helpful written case, commissions are paid for and aware. The court agrees that the factors in this non-exhaustive list will normally be relevant, size of commission, etc. Now bear in mind, this was not a DC case. So we don't have the conflict of interest and all the other things.
Yep.
And that's kind of hinted at in parenthesis, where it says because, for example, a discretionary commission may create incentives to charge a high interest rate. So there's sort of a nod to it, but in a non-DC case, these are the factors that are thought to be relevant. The interesting thing about this is, although my learned friends say, well, it's all very important, holistic, all very individual, the facts of Johnson, in terms of the Supreme Court dealing with them, are very generic and high level. They don't refer to his witness statement saying he said this or said that, beyond that he didn't read anything, and he was unsophisticated. And by dint of those two facts, they said that he hadn't had the commission disclosed to him, and that the relationship was unfair. And it wasn't limited to Mr. Johnson. If you go to paragraph 327, opposite letter E, where they say, even when allowance is made for the exaggeration in his evidence, it's clear the amount of the undisclosed commission would have been a major consideration in Mr. Johnson's mind had he been aware of it at entering the agreement, as it would to any similar customer. So it's not looking at Mr. Johnson particularly. This is a sort of generic finding that any customer wouldn't expect a commission of that type. Now, apply that wording and thought to a DC commission. Is it really to be suggested that any customer, I must say I hadn't heard of these things before involved in this case, go into a dealer and he gives you an interest rate, is a customer really to be taken to know that there's not a fixed interest rate? He can charge you a range and pocket the benefit? No.
No.
So if we go on the same point at paragraph 336, opposite E, dealing with disclosure, Mr. Johnson, however, it must be pointed out, he was commercially unsophisticated. It must be questionable to what extent a lender could reasonably expect a customer to read and understand the detail of such documents. Furthermore, no prominence was given to the relevant statements in the docs. Those were the statements that said that a commission may be charged. In the case of FIR's RAND standard terms and conditions, 13.6 was surrounded by a mass of other terms. It ought to be pointed out that particular attention was drawn to clause 10, but not clause 13.6. A customer would not expect that a commission of this size would be payable, and as a result, a term of importance of clause 13.6 is required to be displayed more prominently, and they refer then to the ticket cases. So again, very high level, generic, unsophisticated customer. You've not disclosed these commissions adequately. No customer could be expected to read all this. Unfair. You can only imagine what they would do in a DC case, given the inherent conflict of interest in that relationship. So what I say is, the same happened in pleading. Look at facts of pleading they're dealt with. They're all very generic, unsophisticated people. They don't turn on the individual, the minutiae of the individual circumstances. The nearest they get is that they're sophisticated or unsophisticated. So the respondents pleaded cases that unfairness here has been caused by the non-disclosure of a DC commission, something done or not done, in the rubric of 140A to C. Our cases, that was sufficient by itself to cause unfairness absent any countervailing factor. There is no need for the respondents to rely on an accumulation of other factors to get their case over the line. In any event, if there were other factors potentially in play, then they could be identified in sampling and dealt with to get the maximum utility from the lead cases.
Sorry, when you say if there are other factors, you mean other factors?
Relied upon by the defendants, if they came up with the facts.
By the defendants?
Yes.
Yes, but as far as the claimants are concerned, you say it is simply the fact of the discretionary, the secret discretionary commission.
Non-disclosed.
Yes. Sorry, okay. Not non-disclosed commission.
Correct.
And that's it.
Yes.
And you just want a ruling on that?
Well, we want a ruling in the context of a range of circumstances.
I understand that.
Because the interest rates may differ,
Yes.
And you know, the broker may be super greedy.
Yeah. Hence sample cases.
Exactly. Now, examples where the balance may come down against the consumer, we say will be rare, but we have the dishonest claimant in Kerrigan. Remember, the judge didn't deal with that because he thought the claimant had been dishonest. Excessive delay on the part of the debtor in Smith, and also repayment and disclosure in Smith, and then the bona fide compromise in Self. So those are the kind of situations. But where the appellants as here seek to rely on more run-of-the-mill features of the relationship, as balancing out the unfairness that the Finch factors, it's difficult to see how that begins to pass muster for the reasons I say. But even if I'm wrong about that, and there's a particular Finch factor they can identify, we can have that in and run that in the test cases. It doesn't make it unsuitable thereby for an omnibus claim form. That's where they go to. They say, by dint of the Finch factors and other things, it's therefore not appropriate for an omnibus claim form. Incorrect. A, because there's no basis for what they say, that this really could be a runner. But even if it is, it can be dealt with within the confines of an omnibus claim form. Doesn't make that omnibus claim form inappropriate. And we say where the same non-disclosure is replicated across a large number of materially identical transactions involving consumers, all of whom are ignorant of the withheld information, and where the credit agreements entered into are otherwise unremarkable and the circumstances commonplace, then, we say, it's common sense to anticipate that if an unfair relationship was arisen in one case, then the same result will almost certainly eventuate in the others, whether within that group or the following ones that aren't part of test claimants.
So not binding, but persuasive.
In relation to the fairness issues, but binding in relation to the construction of the comp rules.
Yeah, to the extent there's a dispute about the construction of the comp rules.
And an agency that they've now conceded. But it didn't before the judge, importantly. That's the important point on agency. They did not concede that before the judge. For him, they were disputing that Section 56 applied. Section 56 didn't apply, then we're out, subject to 1.2.2, because it's Section 56 that makes the 4.5.3 failure to disclose by the broker actionable against the firm. So it's of absolutely crucial importance. It's not an also-ran point. They did not concede it, and they've been bullied into it by reason of these proceedings effectively being brought on a collective basis.
Yeah. We finish with Johnson.
Finish with Johnson, my lord. The same approach applies to remedy. We deal with this in our skeleton at paragraphs 99 to 111. I'm not going to dwell on it. But just as unfairness under Section 140A, there are unlikely to be distinct individual factors in each case capable of affecting the approach to remedy other than arithmetic.
Capable of affecting the approach. So I'm just picking up, making sure I heard what you said. There are unlikely to be factors affecting remedy in individual cases,
Which are capable.
Which are capable of affecting the overall outcome, or the overall principle.
Exactly.
Yeah, got that.
It's uncontroversial that the purpose of the remedy, this is Smith in Leggett, Leggett and Smith at 25, is to remove the unfairness. And what you sometimes get, you've got in Johnson a repayment of the commission. There's different ways of doing it, but these are details essentially to ensure that fairness is the keystone here.
So sorry, following my Lord's question, what is in relation to remedy?
Well, we say that there is likely to be commonality in the approach. That there'll be difference, obviously, in individual cases in terms of the arithmetic. But where you've got 10 or 15 lead cases, there'll be sufficient variety for the court to, on the same approach, which is obviously to identify the unfairness and remove it, to provide an appropriate remedy. That's not the reason, if otherwise it was convenient to determine these claims on an omnibus claim form not to.
Well, certainly speaking for myself, remedy is certainly a lot lower down any scale.
You've got to get there first.
Yeah, exactly. I mean, in most group litigation, even if there's a complete synthesis of issues of fact and law for liability and causation, damages will always be a separate exercise.
No, yes.
My
That's
recollection
why
is,
Mr. Justice Constable's in the room.
I was
in-
going to
in
say,
the court, dealing with quantum on Dieselgate.
and if my recollection is right, my Lord went through a whole load of potential claims of citizens of Kenya,
Colombia. Oh, Kenya. Gala.
who suffered pollution. All their claims were different. So one recognises that. But again, we're back to the lead cases point.
We are.
Yeah.
So if I move on then to the alternative put forward by the appellants, the non-alternative.
The what, sorry?
The non-alternative. If we go to the supplementary bundle for this, please.
Right, well, I've got a heading, the non-alternative. You can tell me what that means.
Well,
Supplemental bundle.
my lord, yes. Tab 12, please.
Page.
155.
Thank you.
So I was asked by the judge at the bottom of 154.
Now, what is this?
This is a transcript of the hearing for Mr. Justice Ritchie.
Which hearing?
The main hearing dealing with 7.3.
So not the consequentials.
I didn't attend that, my lord, no.
Oh, right. Oh, sorry, I didn't know that.
No. So this is
the transcript of the main hearing.
exactly. And he's asking me at the bottom of 154 if I don't set the report, what would that look like? And I say it would be a disaster. And he says, I understand. Well, tell me rather more than just commenting. So I do. Opposite C. The four winds to other courts, to the local courts, the defendant suggested no case management beyond the norm at all. So you'd have district judges and county court judges throughout the land deciding questions of principle to the meaning of the Consumer Credit Act, regulatory rules, and then applying them in different conflicting ways. There are then the appeals, potentially from those to the Court of Appeal, the county court, maybe the Court of Appeal, in an unmanaged, unfocused way, no particular order. It'd be happenstance. And he says, right. And
To be fair, this is your strictly neutral exposition of the other side's case.
well, it's my strictly neutral exposition of my submissions to be the result of the other side's case, my lord.
Apocalypse Now.
Exactly. So let's see on the other side. The judge very fairly asked my learned friend, so it's page 165, tab 14. Opposite E and F, Mr. Justice Ritchie, what are the defendants that you represent suggesting for the way forward? They are suggesting the claimants, if the claimants actually have individual claims, they should bring them. And the judge says, I've got that, honestly. Yes. What are you suggesting going forwards between there and disposal? Usual process under the small claims or fast track as appropriate. So no conjoining, no test case, no lead cases, just 5,000 separate cases. Yes, my lord. Thank you, I understand. So, my lord, that was the whole approach to the whole thing. That there was no alternative put forward, there were no concessions made. This was, as my Lord Justice Stuart-Smith said, battered in trenches, and they were taking their position. Now, we say, of course, that's no alternative at all. And my learned friends say, well, things are going swimmingly and this is all fine. It isn't fine in the county courts, because these kind of claims are highly complex. Deciding these conc issues for a deputy district judge, whatever, in a county court to determine these complex issues is very difficult and time consuming. Can we go to a case called Young Santander, where a county court judge said this? So it's Authorities 3. Tab 41, page 1017. This was a single claim, a motor finance claim of this type. And could you read paragraphs 2 to 5 briefly to yourselves?
Paragraph
2 to 5.
Yep.
So you can see that when these claims are brought forward and argued properly, there's obviously a concern that for a small claim, this really isn't an appropriate use of legal resources, court time, and such like. And then we get a similar point from Johnson in this.
Well, yes. I mean, to be fair, Judge Gosnell is not necessarily saying. I mean, he's not criticising counsel, but he is saying that the point is that the way this appeal has been approached is completely disproportionate to the issues.
Right.
So he's not necessarily saying that the issues are overly complicated. He's just saying it's been approached disproportionate.
But I think what he's saying is, and what I infer he's saying is, because these issues are complex, and they are, if you're going to, as the defendants are, defend all these cases and turn up with lawyers and barristers, then it's inevitable that that's what you're going to get. And what impact is that having on the county court? Let's look at Johnson.
So can I just check? Mr. Butters was for the appellant.
Indeed.
Instructed by bearings?
Say again, my lord?
Instructed by bearings?
No.
Instructed by...
HD Law, my lord.
And are they
Assistant
involved
Johnson.
either at the front or at the back in this dispute? I mean, are they running hundreds of cases?
My lord, they do have a number of cases. They were the solicitors in Johnson.
They were the solicitors in Johnson. And Ms. Barlow for the respondent, instructed by, you know?
Santander, my lord. I'm not sure who the solicitors were, I'm afraid.
Okay.
Okay. I mean, what I'm trying to get a feel for is whether this is one step in the ongoing, one skirmish in the ongoing battle.
My lord, there are a great many number of individual claims that have gone on appeal, and the summary given by His Honour Judge Gosnell is not an unfamiliar one.
Right. Thank you.
That's very useful, and I'm sure, Mr. Butters, you would agree with me that Judge Gosnell is possibly the best civil judge, now sadly retired, but the best civil judge on the North Eastern Circuit.
That is right, my lord.
Mr. Cumner, the time has flown.
Lord, yes.
It's just gone 1 o'clock, so we'll come back at 2. Are you on track for your
Lord, yes, I think
timings?
so. Yeah.
I mean, we can come back slightly early if you want us to. You seem to me to be, but obviously
Lord,
you'll
yes,
know
no,
that better than me.
No, we're fine.
Fine.
Thank you very much.
2 o'clock.
Court ready.